For the appellee here is both sound and video. And I guess I need to find out the parties' positions with regard to proceeding forward if we don't have the video for Mr. Bogdanoff. Is it Miss Alanya? Is that correct?
That's correct, yes.
Do you have any objection to proceeding with the oral argument if we don't have the video from Mr. Bogdanoff?
No, I do not.
Okay. All right. And Mr. Bogdanoff, do you have any objection to proceeding with the oral argument here online if you're not on video?
As long as you can hear me, I would prefer that we move forward. If you can hear me, I'd prefer that we move forward.
Okay. Then we will do that. I will begin by introducing myself. My name is Rand Wallace. I'm here presiding over this session of oral argument for the 5th District Court of Appeal. We have one case on the docket today. Joining me on this panel, we have Judge Meredith Sasso from Orange County and Judge Carrie Ann Wozniak also from Orange County. I've just asked counsel to make sure that any devices that make noises, please mute those. And also when you're not speaking, mute your microphone. Miss Alanya, you are the appellant. I'm going to assume that you want 5 minutes of rebuttal unless you tell me otherwise. And other than that, you may proceed.
Thank you, Your Honor. Melissa Alagna of Florida Appeals on behalf of the appellant, the former wife, Suzanne Aaron, and I would like to reserve the 5 minutes for rebuttal. This appeal stems from a dissolution of marriage proceeding. The parties here were married for 6 years, and the primary issue before the trial court was the equitable distribution of their assets. The main asset was the marital home, and it's our position that the trial court erred in unequally distributing the marital home based solely on the financial contribution of the parties to its purchase. The standard of review is the abuse of discretion. Prior to the trial, the court had made a determination that the home was a marital asset because it was purchased after the marriage, and the issue at trial was how it was going to be divided between the parties. Ultimately, the trial court awarded the majority of the home to the husband. The home appraised at approximately $930,000, and the husband was awarded more than $800,000 of that value, and the wife was awarded approximately $122,000. Section 61.075 governs the equitable distribution of marital assets and tells us that we start with the proposition that the distribution should be equal, and provides a list of factors that the trial court must consider in determining what equitable distribution is appropriate. And the trial court reviewed those factors in this case and ultimately decided that only one was applicable, and that's subsection 1G, which deals with the contribution of the parties to the acquisition of the asset. And there's no dispute that of the $525,000 purchase price, the wife contributed $69,000 and the husband contributed the balance. On the order of the motion for rehearing, the trial court focused on that contribution and essentially said that the husband's contribution was substantial and the wife's contribution was roughly 15% of the total purchase price. And so based on that, determined that the distribution should be unequal. The issue is—
when you say that the only, and Mr. Bogdanoff, I think if you could mute, I'm getting some feedback. I don't know if anybody else hears that. Thank you. Is it your position that the trial court found only one factor was applicable, or considered all the statutory factors and considered that this was maybe the dispositive factor, but took everything into account?
Well, the trial court took all the factors into account and just said that the other ones had no weight on its decision, and that this was the only one that was relevant, the contribution that each party gave towards the acquisition of the home. And the issue with that is that the case law says that that's in and of itself is not sufficient to justify an unequal distribution of the property. We cited to 2 cases for that proposition. That's the Williams case and the Stowe case. In the Williams case, the appellate court, the 4th district, reversed an unequal distribution in favor of the husband. and stated that it did not want to allow a situation in which every trial court had the discretion to unequally distribute assets solely based on the fact that one party made a greater financial contribution or even a premarital contribution in the absence of any.
The Williams case also highlights the kind of the absence of any other compelling factors in that case. Do you think that the Williams case lines up with this case because the trial court apparently found that, you know, the compelling factor aspect in this case might have been a little different from Williams? Do you think that should weigh on our decision at all?
I think this case lines up with the holding of the Williams case because I don't think the trial court had any compelling factors. I don't see that it considered any other, that it raised any other factors, compelling or otherwise, beyond the contribution of each party towards the purchase price. And for that reason, because there were no other compelling factors, I think it lines up with the holding of the Williams case, where if we're just looking at what each party put in towards a purchase, that in and of itself is not enough. And that's consistent with what the first district said in Stowe as well. In that case, they also reversed on unequal distribution in that time in favor of the wife, which was based on the wife's contribution of most of the funds necessary to purchase the marital home. The first district essentially said the same thing, that a trial court can't base the unequal distribution on a spouse's disproportionate financial contributions unless there's a showing of extraordinary services over and above the normal marital duties. And there wasn't, that showing wasn't made here either.
Weren't there factual differences weren't there factual differences between those two cases, Williams and Stowe, in this case as well? The marriages were longer in those cases. I think in one of them, the wife ended her employment to rear the child. The assets were commingled, things like that, that didn't seem to be present in this case.
Yeah, so the duration of the marriage in the Williams case, and that's the case where the wife also was rearing the child, the duration of the marriage in that case was 9 years. We have a 6-year marriage here. And the duration of the marriage in the Stowe case, that was a 19-year marriage. So that was a bit longer. But the factors that the courts are looking at in both those cases and the holdings in both those cases come down to the fact that the financial contribution alone is not what we're going to look at. We have to consider more than, if that's the only thing we have available to us, then that won't be enough. We'll have to have some other sort of compelling factors. And that's the same thing that happened in the cases that the husband cites. So the husband raises the McMonigle case, which is actually out of this court. And those cases are actually on the other side of the spectrum. Those are shorter marriages. The McMonigle case is a marriage that's less than 2 years. And in that case, the husband owned the property prior to the marriage. So it's distinguishable on that fact as well, and then deeded it to the parties after they were married. And basically, in what McMonigle says is that they're reversing the lower court's decision because the lower court did not consider the factors of 61.075. And obviously the statute requires that to take place. And so based on that technical requirement, the court reversed, but it didn't foreclose the possibility of an equal distribution. It just said that the court had to consider all of those factors before it could distribute the property. The second case they cite is the Vogelstein case, and that's the shortest duration we have, right? That's a 6-week marriage, property owned again by the husband prior to the marriage and deeded to the parties jointly after the marriage. That case, the appellate court just said that the trial court had considered the factors, made findings of fact that were based on competent substantial evidence, and so it wouldn't disturb the trial court's decision. But the trial court's decision didn't appear to be based solely on the husband's financial contribution. The trial court there seemed to be concerned with the short duration of the marriage and the fact that after just 6 weeks, the husband could walk away from the marriage with about half of the value of the assets he came into it with, while the wife was going to double the value of the assets she came into the marriage with. And that's simply not the case here. And we
Why
believe
isn't the lesson keep getting this feedback? Simply that the trial court's required to consider the statutory factors, and within weighing those factors, if the trial court considers the factors and there's nothing about the situation that suggests that the trial court didn't consider it, why would it be an abuse of discretion in this case to say, it was, they didn't have children, it was these non-marital assets that they used to fund the house, there's a disproportionate contribution by the parties before their marriage to contribute to this asset. I'm going to do it proportionally. I don't see any reason why it should be split equitably. It's obvious in this case. I mean, why isn't that something that trial court has discretion to do?
I think that would put us squarely into the situation that the court cautioned against in Williams. That would put us into a situation where in every case that there's a disproportionate financial contribution, then we would essentially start with the proposition that there's going to be an unequal distribution, as opposed to starting, as the statute requires, with the proposition that we'd have an equal distribution.
And I think, Williams cautions against that, but does not stand for the proposition that you can never, after considering all the circumstances, the trial court can never, after consider the circumstances, award a disproportionate amount of the asset based on the facts of that case. Wouldn't you agree with that?
Yeah, so there's definitely not a requirement in all cases that there must be an equal distribution. The requirement that I see in Williams and in Stowe is that if the only factor we have at play is going to be the financial contribution of the parties, then that wouldn't be sufficient. As Williams said, unless there are other compelling factors. If there aren't any compelling factors, then we stay where the statute starts us, and that's at the equal distribution.
What is your response to the argument that there's this tipsy coachman basis for affirmance on this issue, even if this court accepted this argument on whether or not the factors were compelling enough, because it was obviously, just because the money was spent from a fund that was deemed marital is actually non-marital funds?
So I believe that plays to the issue of the improvements, of the credit that was received for the improvements. And that was the $142,000. So if we start with the proposition that the court had determined that the house was marital, if any portion of that property is going to be deemed non-marital, then the husband, if he's going to suggest that some portion is non-marital, would have the burden of providing evidence that those improvements were paid from non-marital funds. And the evidence before the trial court was simply the husband's handwritten list of different expenses that were paid. And then it had a list of either check numbers, or it would say like Visa, that it was paid from a credit card. There was an item on there for a contractor that was paid that didn't distinguish where it was paid from at all. And so simply the competent substantial evidence regarding where those improvements or the source of the funds to pay for those improvements, it was just lacking. It wasn't there. There was no evidence presented of the source of where it was paid from. So the check numbers don't tell us what account it came from. I know the brief mentions that it came from the 5080 account, the SunTrust account, and that it came from the sale of the home in Georgia. But the documentary evidence doesn't support that, because it tells us check numbers and it tells us that it came from these Visa cards. We don't know where those credit cards were paid from. There was no evidence of that either. And even as to it came from the Georgia property, there wasn't anything beyond, I believe, the statement made in the transcript that that's where it came from, but the account numbers or the check numbers didn't specify that that was money that was deposited in there from the sale of the Georgia home. So it's our position that the competent substantial evidence would not justify a finding that those $142,000 in improvements came from non-marital funds. We also believe that the trial court erred in failing to distribute that bank account, the SunTrust bank account. It's referred to as the 5080 bank account in the briefs. In the order on the motion for rehearing, the trial court found that account to be marital. It was the husband's position that the trial court made a conditional statement that it was marital, but didn't make an actual finding. And that's based on a sentence in the order that says, consequently, this bank account is indeed a marital asset if it was used during the marriage for and commingled with marital income and expenses. And if you read that sentence on its own, I can understand the husband's argument. However, if you read that paragraph as a whole, it's clear that that wasn't the trial court's intent. It references that account as the marital bank account at least 2 times in that paragraph. And so it's clear that they made a finding that that account was marital. And the trial court stated it didn't include that account in the equitable distribution, not because it was non-marital, but because they didn't have evidence of the balance at the time of the filing or at the time of the trial. The wife suggested that that account should be valued as of the time of filing and presented a bank statement that showed that it had at least $66,000 in it at the time of filing. And I say at least because, as the trial court noted, the bank statement was cut off. You can see the 66 and the comma, but you can't see the last 3 digits of the number. They're unclear. That's at record page 717. And in any event, the trial court said that was insufficient, that she would have to have evidence of the balance at the time of the trial. There was never an argument made by either party that it should be valued at the time of trial. And there was never evidence presented of what the value of the account was at the time of trial. And so it erred in failing to distribute that account, even after finding that it was marital. And actually, as I'm looking at the clock bottle,
I have one question. I know you're on your rebuttal time. Can you hear me okay? Because I know that there's some echoing.
yes, I can hear you.
Okay, okay, good. Was there a verbal or oral ruling that's in the transcript that the trial court made as to whether the bank account was marital or non-marital? Because the sentence on its own, it is, I'm not sure if it really is a ruling on that. Is there anything in the transcript to boost that?
No, unfortunately, there's not. So there was no oral pronouncement at the trial on any of these issues or any sort of ruling that's in the transcript.
Okay, thank you.
Okay, Ms. Alanya, I failed to mention there's a cross appeal in this case as well. So I would have said, I'm gonna, allow you just to divide up that time however you want to. I'm gonna add some time when you come back for rebuttal so that you can address issues that are raised by Mr. Bogdanoff on the cross appeal. So add about 5 minutes to your presentation at the end, just to let you know. Okay?
Thank you. Thank you.
All right. And Mr. Bogdanoff, you may proceed. And obviously you have issues to address in your cross appeal as well that I will expect you to just manage yourself within your allotted time. Okay?
Yes, sir. May it please the court, John Bogdanoff for the former husband. Can you hear me?
Yes, we can hear you.
Okay, thank you very much. As to issue 1, all 3 of the issues raised by the wife are governed by the abuse of discretion standard. As to issue 1, the trial court made extensive findings of fact in the final judgment. These findings of fact not only included the fact that the former husband had utilized the bulk of his premarital assets in order to purchase the house, while the wife had provided $69,000 of the $525,000, which the court indicated was less than a 15% contribution. But the court made additional findings. The court found that the former wife kept all of her premarital assets for herself. She kept them intact for herself, while the husband had utilized the bulk of his assets to purchase this house. Unfortunately, he was a little bit short, and in order to avoid losing his deposit, as the court found, the wife provided the $69,000. the court again made a finding that this was not because she expected to have an interest in the house, but because she was attempting to save the husband's deposit. So, there were additional findings, and probably one of the most significant was the fact that she kept her premarital assets to herself, and the husband had used the bulk of his premarital assets to purchase the house. So that was one of the real equitable factors that the court was taking into account. The statute 610751 talks about equal division unless there's a justification for an unequal distribution. And the McMonigle case talks about that. In that case, this court reversed an equal distribution in a marriage that was approximately 2 years in length, and sent it back to the trial court saying that there are cases in which it may be a good starting point to consider an equal split, but it should not end in an inequitable result. And the court reversed the equal split of the assets in that case. That case is very similar factually to this case, in that the parties in that case had been previously married, had substantial premarital assets. The wife kept her assets, as in this case. She kept her assets to herself, her premarital assets, and the husband utilized his premarital assets to purchase a house.
What is your response to the citation to Williams and Stowe and the case's emphasis on compelling factors or extraordinary services over and beyond the normal duties, that sort of language?
Well, neither of those cases apply here for a number of reasons. One of them is one involved an intermediate length marriage in which the wife gave up a job and her career in order to stay home and raise the kids. So there were substantial contributions from the wife in that case. In this case, the trial court found the only contribution that the wife made in this marriage was the $69,000. That was it. So in Williams, you're dealing with long-term substantial contributions. You don't have premarital assets. The former wife had not been married previously in Williams, so she did not enter the marriage with premarital assets. And the appellate court found there were no compelling circumstances warranting an unequal distribution. The case is totally different than ours. Likewise, Stowe involved I believe it was an 18-year marriage. Again, no premarital assets were involved in that case. It was a long-term marriage. Contributions from the wife, extensive contributions. Those are totally different cases than this case. The trial court made extensive findings of fact here, and those findings distinguish our case from those cases and make this case much closer to the McMonigle case. We don't believe there was any abuse of discretion in the trial court's ultimate decision based on those findings to determine that there was a justification for an unequal distribution here. So we would say that the wife has not established any abuse of discretion. The facts have to be viewed in the light most favorable to sustaining the judgment. And under those standards, it cannot be said that no reasonable judge would have taken the view adopted by the trial judge in this case. In addition, there was also evidence in this case that the former husband paid all the household expenses during the marriage. So we have a situation where the sole contribution, as the trial court found by the wife, was the $69,000. So this case is much closer to the McMonigle case, and under the statute, the court had the discretion to award an unequal distribution. As to the account 5080, there's several reasons why an affirmance is required. Number one, the order on rehearing is iffy in determining whether, uses the word if the account was used, was a marital asset. It doesn't make a straightforward determination that it was. But even if the court had made that finding, which it didn't, but even if it had, the case law is clear The wife's argument was simply that because the husband paid expenses, joint expenses out of the account, that somehow transformed the account into a marital asset. We cited numerous cases, Greco, Lakin, Puskar. All those cases hold that the simple act of paying joint expenses out of an account, an account that's solely the property of one spouse, does not transform that account into a marital asset. In this case, the wife acknowledged she did not establish that the husband had deposited marital assets into the account, and the husband's testimony was crystal clear. He said the only deposits he made to that account came from non-marital sources. So the evidence was absolutely clear that the only aspect of that account was that it was used to pay joint expenses. And under Florida law, that's simply not enough to transform the rest of that account into a marital asset. And we believe that was.
What do we do with that argument? And this kind of dovetails to your cross appeal, but I think you presented that argument as a tipsy coachman argument. You can correct me if I'm wrong. And if that was a finding by the trial court on rehearing, why is that something that would not have needed to be cross appealed?
Well, we have cross appealed the trial court's decision as to awarding the improvement expenses, or at least one half of them, to the wife. But
isn't that predicated though on the finding that, I mean, the specific finding that the account was marital? And I understand the language is not as specific as it could be. But I think, I mean, correct me if I'm wrong, but I think your cross appeal is kind of predicated on that same argument, right? That this distribution was an error because of the nature of the account.
Well, yes, the argument is that because the former husband testified that all the expenses associated with the improvements he paid either out of his account, out of his credit card, or from his premarital property in Georgia, all sources that were his sole property, that the wife had failed to establish that that any marital monies were used to pay for those expenses. So yes, I mean, there is, some relationship there, but it was very clear from the evidence presented that the only thing that the husband utilized account 5080 for was to pay expenses. And that does not, as a matter of law, does not transform an account into a marital asset. So, that we believe is a tipsy coachman argument, that the court reached the right result, perhaps for the wrong reason. But in addition, the court found that the former wife had failed to establish the balance in the account. Now, she argues, well, I presented a statement, even though it was partially cut off. I presented a statement from 2018 that would have established the balance in the account. Well, the trial court did not, first of all, believe that statement was sufficient because it had been cut off. It was not a complete statement of the account. There were parts of it that were cut off. But in addition, the trial court valued the marital home as of February 2021. The trial court did not determine that assets should be valued as of 2018. So since the only other asset was the marital home, which was valued effective February of 2021, the wife's argument that somehow this bank account should have been valued as of 2018 is simply incorrect. And she cannot hold the trial court in error for failing to find that account should be distributed in part to her, where she failed to establish the value of that account in 2021, which is when the court determined the value of the home should be made. And that's when that value was established. So there's numerous reasons why the trial court did not commit reversible error in connection with treatment of account 5080. And the third argument, which kind of is related to that argument, the wife talked about claim of dissipation of marital assets. Well, the trial court made a specific finding that there was no dissipation of marital assets from account 5080. So that finding is supported by substantial competent evidence because the former husband testified that the only money that he took out was $50,000 that he sent to his daughter, which was based on the life insurance of his late wife. And that would have been a source unconnected with the marriage. So even if we got to that point, the judge made a finding which is supported by the evidence that there was no dissipation of marital assets. The point on cross appeal, as you've touched on, relates to the increase in value of the property due to some improvements that were made in the amount of $142,525. Now, the husband testified that he paid for those improvements from his non-marital sources. There was no testimony from the wife as to that those improvements were paid for from marital assets. In fact, her argument below was she was denied an opportunity at the trial to present evidence on that issue because the court ruled that time had run out and she hadn't completed her case. She asked for additional time below in her motion for rehearing, but the trial judge said no, time expired, and the trial was over. She hasn't raised an argument on appeal as to the ruling on that matter. And so she's acknowledged that she did not present evidence below that the improvements were paid for from marital assets. So all we have in the record is testimony and documentary evidence from the husband that he paid for those improvements from non-marital sources, which included his account 5080 and some property that he had in Georgia that he sold, premarital property that he had in Georgia that he sold. And in fact, the wife acknowledged that the proceeds from that property in Georgia had in fact been used to pay a portion of the improvements. She wasn't very happy about it. She felt the husband was foolish and should have gotten an annuity with that money. But in any event, she did acknowledge that he did utilize those non-marital monies to pay for many of the improvements to the property. So all we have in the record is evidence that the husband paid for those improvements with his own non-marital funds. So,
but the trial court found that that evidence was insufficient, right? In the order on the motion for rehearing, paragraph J, it was within the trial court's discretion to find if that evidence was insufficient or not, correct?
Well, the trial court made that finding, but there was no evidence that it was paid for with marital funds. So we have a situation where the only evidence in the case was that those improvements were paid for by non-marital funds. There was no other evidence. So the trial court's finding leaves us in a position where, as the wife acknowledges, she did not present evidence that the improvements were paid for by marital funds. So the sole evidence in the case was that the husband paid for these from non-marital funds. So I think the judge perhaps didn't have the benefit of a transcript, obviously in connection with the motion for rehearing. I think the judge, I don't think that finding can be sustained.
Well,
because
whose burden is it to prove it was non-marital or marital? And then also maybe this is rephrasing the same question, but is there a presumption that marital assets were used versus non-marital that had to be overcome?
Well, the work was done during the marriage. So the husband would have the burden of showing that it was non-marital funds, but he clearly carried that burden because there was no other evidence. The only evidence in the record is that those funds, those non-marital funds of the husband were used to pay for the improvements. And that's it. There's no other evidence. So it's not that the judge can say, well, I believe her, I don't believe you. There's nothing else. So I think in this case, the only substantial competent evidence in the record is that the husband used non-marital funds to pay for those improvements. And there's no other evidence in the record. So I don't think that finding is sustainable on the record. If the panel has any other questions, I'd be happy to answer them.
I guess I just wanted to follow up again. I think we have to assume, to get to your argument, that the trial court erred in a determination that account was marital, and I'm just concerned with the way that was presented in terms of a tipsy coachman argument in the initial brief, as opposed to a separate issue raised in the cross appeal. And so I guess, do I understand your argument that essentially, because the evidence, there's only one view of the evidence, regardless of that factual finding that went unchallenged, that this court could still address the issue on cross appeal without that kind of threshold issue being challenged as well, or relief from the threshold issue being
Our
sought?
initial argument was the court did not make an express finding.
Mm-hmm.
So therefore, there was nothing for us to cross appeal because the court did not make an express finding. If anyone should have appealed that issue, it was the wife. She should have appealed the absence of an explicit ruling from the court that the account was, if the court intended to find it was a marital account, the court did not specifically do that. So there was nothing on that aspect of it to cross appeal. Our argument is the court didn't make an express finding, but even if it had, that under Florida law, the cases that we cited, there is no view of the evidence that would support finding that account to be marital, because it was only used for the purpose of paying marital expenses. No marital funds were ever deposited into the account. The evidence is absolute on that point. And so the only evidence was funds were used to pay joint expenses. And under Florida law, that is simply not a basis for finding it was a marital asset. And then the final argument is that there was no determination of the value of the account at the time or just before trial, that the only evidence that the wife presented was a 2018 statement that was cut off. And 2018 was not the time when assets were valued in this case. The marital home was valued in February of 2021. So there again, the wife has not established error in the court's failure to value this account as of 2018, because that was not the proper valuation date. So there's numerous reasons why an affirmance on issue 2 is warranted in this case. Okay, thank you very much.
All right, thank you, Mr. Bogdanoff. And Miss Alana, I will give you, you've got a little under 4 minutes. I'll give you a total of 9 minutes, add 5 so you can address the cross appeal.
Thank you. I wanted to address an issue under issue 1 with the distribution of the marital home. So counsel made the argument that the court considered the parties' premarital assets and how they utilized them in determining that an unequal distribution was appropriate. And the language of the final judgment suggests otherwise. The court says that the court found subsection 1B, which is the economic circumstances of the parties, to be of little consequence because they both came from a financially comfortable lifestyle. And that's true of all the other factors except for the contribution to the purchase of the marital home. So I think based on the language of the final judgment and the order on the motion for rehearing, it's pretty clear that the court only looked at that initial contribution and not any of the other underlying factors, and that the unequal distribution was not proper based on that one factor. As to the 5080 account, counsel argued that it's not a marital asset because it was simply used to pay for marital expenses. And the cases that the husband cites in his brief stand for the proposition that the funds that are used to pay the expenses are marital assets, but any funds above and beyond that would not be. So the issue here is that there was no evidence of any funds that were not used to pay for marital expenses. The only evidence we have in the record is the husband's financial affidavit, which suggested that everything that went into that 5080 account went out to pay for marital expenses. And so there's no evidence as to what remainder or what additional funds would be in that account that wouldn't have been marital funds. And that would have been the husband's burden to show what funds were in there that he was not using to pay marital expenses. As far as the argument that the evaluation date as of the date of filing was improper, it was the only argument that was raised below. The husband didn't take a position as to the valuation date for that account. And I think it's clear that different assets could be valued based on different valuation dates. So simply because the home was valued as of 2021 doesn't require that account would also have to be valued as of 2021. The wife argued it should be valued as of the filing date, and the husband didn't counter that or didn't prepare his own argument as to when it should be valued, and didn't introduce evidence of a different valuation date, a different balance as of a different date. And so that argument was waived. It wasn't raised below. As to the dissipation argument, that was a $50,000 check written by the husband on July 8th to his daughter for the purchase of a home, for a down payment of a home. It came out of the account on July 13th. So as of the valuation date that the wife was proposing, the money was still in the account. If we're looking at a different valuation date, then obviously the dissipation would come into play. The court disagreed with the wife's position because the transfer occurred before the filing date. July 8th is a check date, but there's no requirement that a dissipation can only occur after filing of a divorce proceeding. The dissipation just needs to occur based on Romano when the marriage is undergoing an irreconcilable breakdown, which clearly 3 days before the filing date, the marriage was in a position of an irreconcilable breakdown. And for that reason, we believe that if a valuation date after the filing is going to be utilized, then there was sufficient evidence to show that the husband dissipated those funds by transferring the $50,000 to his daughter from that account. There was an argument that life insurance funds were used, but the testimony on that was conflicting. The husband mentioned life insurance, reverse mortgage, money he had available, and the wife introduced as an exhibit a response to request for production at record page 714, where he says that there's been no inheritance during the marriage. So the competent substantial evidence on that point would not have been sufficient to show that the funds were sourced from non-marital funds. And for that reason, we believe that ruling should be reversed. I think I am over my time, but if the panel has any questions.
No, I don't think we have any. All right. And I've got feedback. I apologize. I was trying to troubleshoot that with our IT people as well. So, but anyways, thank you for your arguments, counsel, and we wish you all a good day.
Thank you very much.
Thank you.
Thank you.